Welcome to, welcome to the meeting of the Land Use Committee of Community Board Number 8. My name is Charles Bergler. The lady sitting right in front of me, handling the keyboard, is our district manager, Tara Rubin, and the other folks are the smart people who make this board work. We have one item on the agenda that has been given priority because it raises an issue. There is one additional item which I will ask after this one is addressed. Do you want to do the roll call now?
Yes. I will start with Charles Mordler,
Present.
Marty Walpole,
Present.
present on Zoom, Bob Bender,
Here.
Lee Chong, she's absent, Omar Murray, absent, Adriana Rivera, here, Daniel Rowan, Jessica Sosa, here, Laura Spalter, here. You have a quorum.
Do we have
Um,
iPhone that
Let
identify
me,
themselves?
pardon me?
Do we have iPhone identify themselves?
Okay.
Oh, and there's Daniel.
Down.
We did have.
We have, among many distinguished people with us, there are two I would like to, with your permission, single out. The distinguished former committee chairman of this board, the justice of the Supreme Court of the state of New York, and a wonderful former city councilman, Andy Cohen, who's around before. He may still be around. There he is.
Thank you.
Welcome, Andy. And the other one, of course, is Ted Weinstein, the preeminent expert on housing in the city of New York, in my view. So
now
that's
celebrating 45 years.
Camilla.
I've been saying the same thing for years.
No, it was just noted this week that it's been 45 years for Ted.
Oh, boy, that's very good, Ted.
And Camilla Thomas is here also.
Oh,
from
good,
City
on behalf
Planning.
of city planning, and I thank you. Ladies and gentlemen, the first item on the agenda is 160 Van Cortlandt Park South. That is the subject of a subcommittee of the board chaired by Marty Wolfoff. Marty, you're in.
Okay, want me to go first?
Yep.
The situation in Van Cortlandt Village is not getting better in any way. Presumably they're closer to completion, so that's somebody's good news, but we don't know what completion looks like. And we know that Dennis and company are just not cooperating and not communicating. And so the issue now, there have been numerous complaints concerning noise and with drilling and rock breaking and whatever going on. His relationship with the two families that do not wish to sell their houses have become more and more uncomfortable. They had a permit, a normal city permit for operation during working hours, working days, and I have no idea, I have no knowledge that a request came through us for longer hours and more days, but that's what they're doing right now. So it is a very tenuous situation for those who live down there because they do not know what the future holds for them, and that Dennis is totally incommunicado. So that's the basic news there. The fact that progress is being made in the construction, no one knows what's being constructed. In fact, well, we do have diagrams and we discussed diagrams and the height of the floors and the entries, but we just do not know. We were spoiled, thanks to Chuck. We were spoiled with Stagg because Stagg, who never communicated with the community, set a precedent with the apartment house that was going up, and we were in communication almost weekly, but we had meetings every month, and I thought a good relationship was established. That is not and will not be the case with terms of innovation. The committee as a group have requested of me that um, the tenure of the working group need not continue because the communication, either through me or through the board and to the whole committee, has been effective. And unfortunately, we don't know what more we can do other than what the board and the committee can do. So I don't know that I'm handing in my resignation, but I am suggesting the end of the subcommittee as a functioning group.
Marty, if I may take issue with that, please. To succumb to that kind of an antic on the part of the developer, in my view, and just withdrawing the committee is to succumb, in my view, is a mistake. I will tell you for myself, this developer will never have my vote on any issue at any time in any manner, way, shape, or form. This developer is, in my view, the single worst developer as neighbor in this community. And I was among those who helped establish the worst landlord list, and I'm more than inclined to create one, the worst developer list, and you can guess who, in my view, in my personal view, would head that. They are totally uncooperative with anyone, and it amazes me that city planning persists in ignoring their attitude. Luckily, we have an election coming up, and that'll deal with that issue, I hope. But it is troublesome to me that you would disband it. Obviously, if you think that that is the way to go, I will yield to your view, but that's my reaction. Mark, Bob?
Well, I've been in contact with several members of the committee who have expressed that to me. And let's see how it goes. As I say, I'm in communication with Abba, who's on the line now. And we try and follow up. And Farah does a great job in following up with the agencies. Going back to the original comment that you made in starting, I do not, they don't have to be on our side, but the fact that we get less than satisfactory response from the agencies to whom we complain is not helpful to the situation either.
Let me just make a point to you. We'll hear later in the evening a proposal that, with the great help of Bob Bender, I was able to fashion with him and Adiana prior to the meeting about how we deal with the refusal of city government to support its community boards. And I think this one works, so you'll hear it later. Do me a favor, rethink the issue of pulling out and think instead of an issue, what is it that a community board can do with a developer who is a rogue? Query, is it something useful to make it clear to the people in the neighborhood, this is not exactly the kind of landlord you want to have. This is not exactly the kind of borrower that a bank wants to have. Now, those are the kinds of things that we have to obviously deal with, the legalities of that and how to do it in a fashion that passes legal muster. But I can't believe this group is that bad. But apparently they have done everything they can to make it uncomfortable for the people in an area that is holding itself together, notwithstanding the kind of assault it's getting from this developer.
Chuck, I don't want to leave Marty hanging. I am one of the people who said to Marty, I think the subcommittee had gone as far as it could possibly go. All that's really left at this point is for us to refer the complaints that are coming in from the residents of the area to DOB. And that has been happening. Farah's been in touch with DOB, and DOB claims they've sent inspectors out there and have not found the violations that the people in the community are reporting to us.
DEP was the one today.
Oh, DEP
Yeah.
today, okay, well, so DEP's been involved, DOB's been involved,
DOT.
you know, the DOT.
That's why I wanted to put the inspectors in uniforms,
With
so
no
that they
pockets.
would be identifiable to the community.
Right,
It once was a great business
Right.
enterprise.
all I'm saying here, Chuck, is that I think the subcommittee has fulfilled its role. It's done what it could. We brought all the parties together. We did, as a reminder, we did deny the same developer at 3111 on Henry Hudson Parkway.
But that was on the merits.
Yeah, it was on the merits. It wasn't good. I mean, the fact that he was uncooperative
Right.
on that project as he is on this project made our decision quite easy. But I just want to say, this is not we're not throwing in the towel here. We're not saying, well, too bad, he can do what he wants to do. No, we're constantly in touch with the proper agencies about complaints that come in.
But it seems to me that if we do that with keeping the committee alive, because it may be an opportunity to do something. You'll hear my comment later on, which you and I
Yes, yes.
discussed the point.
Yeah.
Marty, let me see if I can ask you to shelve that point until later in this meeting, so that we can deal with that and the issue right after dealing with Van Cortlandt Park South, all right?
Fine with me. Just want to note, as long as Bob raised it, on 3111 Henry Hudson Parkway, there is already out a notice of demolition. So if you haven't seen that building yet in its glory, you should take a peek at it, but it'll be gone very shortly.
Look, I will tell you very quickly, I think there is a very easy and doable way to deal with the issue of a recalcitrant, non-involving city planning commission and an equally disturbed or disturbing Department of Buildings, and you'll hear some ideas on that in a few minutes. Let me deal with Van Cortlandt Park South, if I may. We have here an issue, and I'll introduce the people who are kind enough to join us tonight on that issue. When the Tishman Spire people appeared before the board in the early stages of the discussions concerning their replacing what was the visitation with housing, there was a significant amount of questioning and commentary coming from some of the local residents in terms of their concern, which is something that lies beneath the surface in many applications, as to whether they would be a vehicle for homeless housing and the like. And a comment was then made, this is not going to be a homeless shelter, this is not intended to be, etc. And more recently, the people who are still not very happy with the replacement have pointed to the fact that the development will have an allocation of something approaching perhaps as much as 15% for formerly, remember that word, Formerly, formerly homeless shelter people. And said, aha, we were misled, aha. The truth was not told. When that first surfaced, it disturbed me, and I got hold of Mr. Lodi, who was the person representing Tishman Spire, or one of the people at the time. And he in turn got hold of the distinguished, exceptionally able former Commissioner of Housing Development Corporation, who is with us now. And
Here's what I found.
Louise Carroll has joined us tonight to talk about it. And we have in addition Ted Weinstein, I should say. And so what I want to do is to get this record as clear as I can. What I would like to do is to make a statement, and then anybody in the world who wants to shoot at it may feel free to do so. There is a provision in law, it's been a provision in law for years. It's not a provision known to everyone, it's a provision known to those who focus particularly on the construction of affordable housing within the confines of law as they now exist. But there is a set aside under certain programs for affordable housing for up to 15% for formerly homeless. That means, and that's the critical question that I'm putting to you, Louise, and to you, Ms. Lodi, is what is formerly affordable housing, affordable shelter or homeless housing people. My understanding has always been that's people who were in the system and are not, and have qualified in the eyes of those who make that kind of determination to be placed in a position where they can go into appropriate regular housing under affordable housing programs. And that, to my mind, is a distinction with a very important difference, because everyone is entitled to pull themselves up by their bootstraps. I think that a contrary view is troublesome to me. Louise, you're on.
Good evening. Thank you so much for inviting us to speak and to clear up some misconceptions. I think before, I'm Louise Carroll. I'm the former housing commissioner for the city of New York under the prior administration. And I'm here with Ted Weinstein, who's a former colleague of mine, and with Payman, who works for Tishman. Before we get into the question of residents, I'd really like to turn to Payman to just refresh the community board on the development and who's in the development and the stage that it's at. So before I I'd like to step down and let Payman step up, and then I'm happy to answer any questions you have.
Yeah, that's a question. Is there a representative of the Riverdale Press here? I guess not. Farah, we have got to make sure that they are told to take a look at this video from tonight, because they started this fire of gossip that was a real serious problem. It deluded even me. Eamon, you're on.
Yes, I'm on. Farah, is it possible for me to share my screen? I just
Yes,
sent the request.
Now,
You should be able to.
Okay, give me 1 second.
Yeah, yeah. Okay.
Can you guys see my screen?
yes.
Okay. All right. So thank you, Mr. Merdler, and good evening, everyone. It's great to be back with you all tonight to discuss our project at 160 Van Cortlandt Park South. Again, my name is Payman Lodi, Senior Director at Tishman Speyer. Louise has already introduced herself. She is our counsel from Catton, and also on the call, the esteemed Ted Weinstein from HPD's Director, Bronx Planning. As I said before, the last time we came to you, we truly value being good neighbors. We really appreciate the thoughtful feedback that we've received since the last time we presented. I'm here tonight because your chairman thought it would be a good idea to give an update on the project and clear any misconceptions related to the housing program that we're developing. Namely, whether or not our building will operate as a homeless shelter in any form, for which I can directly answer right now and say that it will not. With that, I've prepared some slides, and so let me just Here we go. Okay. So just to orient everyone, our project is located on the former Visitation Church site across the street from Van Cortlandt Park, roughly bounded by Van Cortlandt Park South to the north, Putnam Avenue to the east, and 239th Street to the south. Since I last presented to you, we demolished the existing structures. We've closed our construction financing with HPD and started construction this January. I believe Farah has been sharing our biweekly construction advisories, which are meant to inform the community as to our status. So our development will include approximately 340 units of affordable housing. To be precise, it's 338 units with one live-in super. It will also include 70 parking spaces and 170 spaces for bicycle parking. And there will be some indoor recreational facilities and approximately 8,000 square feet of outdoor rooftop space. This is a rendering from the northeast, across from Van Cortlandt Park South. This is a rendering from the southeast on the corner of 239th and Putnam. And this is our street level plan. The building's primary entrances will be on the northeast corner of Van Cortlandt Park South and Putnam Avenue. And where we anticipate many residents will actually use the closer access to the subway station. We'll also have a private entrance through the parking lot that connects to the rear of the building. These are just some of our sustainability features for the project. We're proud to be an Enterprise Green, HPD Enterprise Green community project. We will add rooftop solar panels. And I know that this was very important to Karen Argenti and Bob Fanuzzi, but we did modify the project so that it complies with DEP's unified stormwater regulations. And in addition, our parking lot's being designed so that the surface will include permeable pavement to further mitigate any sort of stormwater impacts. Okay, so now here's the housing program. You can see the affordability mix on the left and the bedroom type mix on the right. 84% of these units will be affordable to families earning between 40 to 105% AMI. Digging into that a little bit further, 50% of the units are targeting workforce AMIs of about 80 to 105%. As Chuck had mentioned before, in accordance with the city requirements, 15% of the units will be set aside for formerly homeless households. In this case, where we have to round up to the nearest unit, making it 16%. I want to emphasize that this is not short-term housing accommodations. These residents will be offered 1 or 2 year leases and offered renewal leases as long as they remain in good standing. And additionally, support will be provided by Breaking Ground, a fantastic organization with a great track record. There is one meaningful difference or change from the last time we presented. Within the past year, the city has settled a fair housing lawsuit that resulted in a reduction in the set aside for local community board preference for affordable units. If you recall, the standard used to be 50%. It is now 20% that's mandated by the city. So those are the AMIs. These are I know that can be a little bit confusing. We thought it'd be a little bit helpful to break this down into the rents by bedroom type. Again, the majority of the units will be in the 80 to 105% columns on the right. But as you can see, these are targeting some of these workforce AMIs. Next, I just want to share an updated construction timeline here. As I mentioned, we started construction in January of this year. We're expecting to continue through the second quarter of 2027. which is when we will start the housing lottery process, utilizing the city's Housing Connect portal, where, you know, at that time, we'll certainly send a notice to the community board and the electeds and all the government and community partners to help spread the word and to share broadly of this opportunity with the community. We expect that lottery to remain open for a few months and are targeting move-ins into the building through the second quarter of 2028. And finally, this is just our contact information. As I stated before, we want to be good neighbors. Farah's been directly in touch with me, as has Chuck. We're very reachable. If anyone sees anything that concerns them or you guys have any questions, please call or email and we'll look into it and we'll be happy to get back to you. And I guess with that, I'll take any questions that you may have.
Let me ask you 3 questions. They are well rehearsed. 1, what is formally homeless?
Sure. These are individuals who've been, I'll take a pass at it, and Ted or Louise, if you want to correct anything, feel free to go ahead. These are individuals who were homeless, have been screened by the Department of Homeless Services for their application to enter in and to get housing accommodations in our building.
Ed, anything?
Ted, you're on mute.
Louise, anything to add to that?
While Ted is unmuting, you know, there are different types of housing, and all of the housing that HPD produces, new construction and preservation, there's always a set aside for the formerly homeless. This development is not special and different in any way from any other HPD produced housing. It is certainly not supportive housing. So when you think of supportive housing, it's housing reserved primarily for people with some form of disability that has social services on site. Maybe it's, you know, mental health, etc. The concept of having a set aside, like a veteran set aside or community board set aside for the formerly homeless, is to make sure that people who can't afford housing, who are ready for permanent housing, who were in permanent housing and couldn't afford it and happened to be homeless, are also able to have access and a priority for permanent housing. So you have women who are survivors of domestic violence, who are in transitional housing that need permanent housing. You have families who work, whose children go to school from a shelter. So there are lots of New Yorkers who are working and can't afford housing, and the city has decided that it needs to prioritize them the way they prioritize veterans, the way they prioritize the community, and the way they have other preferences and set-asides. Ted, I see you're unmuted.
Yep. So, you know, the city has had, as I think everybody knows, an affordable housing crisis, and part of that is a homeless crisis. You know, we know that there's been for some time now, on average, roughly like 60,000 people each night that are in a shelter. That's not acceptable to anybody. And one of the ways that you deal with homelessness with people who are unhoused, as sometimes it's called, is to provide permanent housing. You fight homelessness by providing housing. Louise mentioned a few of the ways. I mean, sometimes somebody has a fire, and they're out of there. You know, we just a few weeks ago in the Pelham Parkway area, there was a terrible fire. 200 families were vacated. So these things happen. But the point here is that, and then it was about, I'd say roughly 6 or 8 years ago was when it became the law that anytime that if city money, HPD money is used to build a building, then there's a 15% requirement for the formerly homeless. And again, we use the word formerly because they got to get rent stabilized leases, just like anybody else who gets an apartment in the building. And the minute they sign that lease, they're not homeless anymore. And so, there's all these different factors that come in together. And, no one knows, it's not, I joke sometimes, it's not really funny, but I joke that it's not like, Hester Prynne who walked around with the A on her, they don't walk around with something on, nobody knows, there's nothing on their door. Um, and, they will live, if they want to live there for 20 years, 30 years, 40 years, as rent stabilized tenants, they have that right, they can do so. So, there are some projects that actually do a higher percentage, this one isn't. And so, this is perfectly legal and fine.
But before I turn it over and move to see if anybody else has a question, let me just underscore something that Louise said. Am I correct, Ted, that this is not supportive housing?
No, definitely not. We have a program for supportive housing that provides financing to build supportive housing. And typically in those cases, 60% of the building are for people who are formerly homeless. And that also, they're going to be permanent, that's permanent for them. But that's 60%. That's not the case here. It's, the 15, they're doing 15.7%, I think it is. That's it. The rest of the people, the rest of the units, 85%, roughly 84% of the units are going to be going through the housing lottery, through Housing Connect.
Mr. Gelman,
Yeah, I'm a little puzzled, because I thought Hyman, Soloti, on the second or third slide, didn't you mention a new beginning or something like that
organization.
as a support?
It's a name of an organization.
It's called Breaking Ground.
Breaking
Breaking
ground.
Yes,
Breaking
breaking
ground.
ground.
Aren't they a supportive entity? So I'm.
So- Yes, can I, and I would like to answer that. So for many years, the city and public officials felt that only supportive housing should have social service providers. And by supportive housing, I mean the 60% of residents that need supportive services, whether it's substance abuse, mental health, disabilities, etc. Over time, we have come to understand that if you have been evicted, if you've lost your home, if you've become homeless, it is possible that those families might need some executive functioning and assistance in order to be able to maintain the permanent living. Also, in some instances, there are people who are moving from neighborhoods near family and friends and their place of worship. And we have come to understand that a little help from folks to settle in with school and groceries and being in a new neighborhood is something that the city should provide. So this is new in the last couple of years that the city has started adding funding for a social services provider to support these residents and to support the community. So they will do things like rooftop gardening or recreational activities. Everything a family might want or need or have a question about, they're able to call Breaking Ground and get support from Breaking Ground.
You know,
Yeah, I mean,
supportive housing is a defined term.
Mhm.
It is a statutory term under the city laws. This is not such a category.
Okay,
They are getting support. They could just as easily be called assisted.
okay.
They are the kind of people who can use help.
No,
Most of us do.
I'm not questioning that, it seems like, from the outside looking in, there's a distinction without much of a difference, that's all. I'm not saying it's illegitimate, not worthwhile, but I'm still struggling with the difference, from supportive housing, that's all.
There's a world of difference between
Okay.
providing assistance to a schizophrenic person
Mhm.
or to a person who is addicted to substances that are inappropriate and the like, and someone who is at a loss that needs help.
Understood. Again, I'm not questioning the
And-
legitimacy.
And if I may, it's called light touch. And it's, you know, if you have been homeless, you know, clearly there are a lot of struggling folks in the city, but some people manage to function better than others. And so getting your rental assistance application in on time, but for the next year, maybe something a family needs help doing. It may be that a family needs help settling their child in school. It may be that the family needs help managing their budget and their expenses to be able to afford the home. So that's what we call light touch services, and it's new-ish. It's been just the last couple of years that the city has been putting in the funding to support that 15% homeless set-aside requirement.
Will they have an office on site?
Yes.
All right, anybody else? Yeah.
How long do you plan to close the right, eastbound lane of Van Cortlandt Park South for this?
No, won't go.
Yeah. You know, it is something that we're monitoring. It will be for the duration of the construction or for the majority of the construction. But again, let's stay in touch with Farah. If it really starts to become a problem, I'm happy to go with Farah to DOT to see if there's some sort of way we can mitigate any concerns or problems that might be.
So the second part of my questions, turn upon the AMI and other issues that are relevant. My view, for what it's worth, is New York's housing crisis is more a matter of not having housing that is truly affordable rather than building more housing for the sake of calling it affordable housing. I'll point out many of the housing units in this town that many people of wealth are there. Having said that, would you please tell me what the average rent, looking at it today and knowing that things change, is aimed at being for a 1 and a 2?
Well, it's broken into the 3 AMI buckets, but and again, at this point, understanding that things may change using the 2024 rents that HPD has stated. For a 1-bedroom, a 40% AMI unit is roughly $1,160 a month. For an 80% AMI 1-bedroom unit, that's roughly $2,320 a month. And for a 105% AMI 1-bedroom unit, that's roughly $3,050 a month.
What is the largest projected apartment there?
We have a 3-bedroom. Well, we have 3 bedrooms, but
What are the projected numbers for those?
for a 40% AMI 3-bedroom, the rent will be roughly $1,615 a month. For an 80% 3-bedroom apartment, the monthly rent will be roughly $3,230 a month. And for a 105% AMI 3-bedroom apartment, the rent will be roughly $4,240 a month.
That sounds sort of affordable to some. All right, any other questions? If-
You said that there's 338 units that are affordable. How many units in total are there?
340.
There's
340?
339.
Oh, right, because a super unit.
One is a super unit.
Okay. And do you know how many of those units are gonna fall under the 80% to 105% AMI?
That will be in the 80 to 105% AMI. That's, let's see.
And that 50% of the units?
Yeah, that's roughly 50%.
And
And
there's
you
two
said
levels.
20% of that, sorry?
I said there's two
Okay.
levels in that grouping that you talked about.
Yes, there's an 80% and then there's 105%. But if you were to aggregate them together, those are that's 50% of all the units.
Okay, and then 20% is going to people who live in the community board?
As a,
Could you
Yes.
no, so can I just correct that? There's a priority of 20%. It's another set aside, right? But what I think, Payman, you should talk about Housing Connect and what you're going to do when it's time to market the units to make sure that the community has
Sure.
a shot.
So as I mentioned before, of course, we will, get the word out with, the community board and the elected officials, but HPD also has what they call housing ambassadors. Basically nonprofit organizations. I think, Ted, there are 8 of them in the Bronx. The one that's the one that's closest to our development is a nonprofit that we've worked with already on a few other social issues in the neighborhood, which is Kingsbridge Heights Community Center. And so they can actually help get the word out, but also help applicants register and qualify for Housing Connect.
Let me stop you a minute there. What I would ask you to do is, and I'm gonna ask Farah to do it, put together a list of some of the more active community organizations. For example, I'd like to see the Broadway Alliance plugged into the same thing, so that you take a look at them as well, for their input. It's valuable. Nobody's saying you have to follow it, but advice is always valuable.
No, happy to take any and all.
And if I may, the way that works now is when it's all computerized, is the computer, when everything is in there, it's past the deadline, and the computer starts churning out, what they do is they automatically first would churn out people who have an address within Community District 8.
Okay.
Anything else, David?
One quick question, to whomever would know the answer, just a sort of a process, question. Let's assume, for the sake of argument, that you are eligible for a 40% AMI rent. And through good fortune, your income goes up significantly, that you're more in the 80 to 105%. What happens to your renter?
So if you income qualified for a unit and you have been selected and you've signed a lease, the city does not recertify your income for that unit typically. This is a tax credit unit, so this has tax credits, so it is true that the city has to maintain a certain level of affordability for the unit. But the way the project is structured, all the low-income units are in one condominium, so that if someone is fortunate enough to make a little more than what is stated as the AMI level for that unit, they're not being evicted. And that then we may have on vacancy, you have to find the right person to rent the unit, but the occupant of the unit will not be evicted.
Will the rent be increased?
No, the rents for the units are set at the AMI levels that Payman showed you, and the AMI levels that are in the regulatory agreement. So for the life of the project, those units have to be rented to people at those levels. If somebody is fortunate, and that would be a great success story for a very low income person to have an increase in their income, but they will not be evicted for that reason. If they choose to leave the unit, the requirement is that the developer has to rent that unit to a person who qualifies at the AMI level that they agreed.
And remember, the
Yeah.
tenants in occupancy are rent stabilized. So if they have a 2-year lease, then when that 2 years is up, then they'll get an increase as per whatever the rent guidelines board that year, 2%, 4%, whatever it is. Like
And
anybody else in the building.
And even those increases cannot exceed the AMI level.
No, I understand. I'm really thinking more 5 or 10 years hence, after promotions and what have you. And and what you're saying, I believe, Ms. Carroll, is that, once a 40%, always a 40%, regardless of what your income evolves to over the years, over the decades. Correct?
That is correct. I will also say that it is unlikely, or we haven't seen data that shows that incomes have moved to the extent in affordable housing that someone would not be entitled.
Please let me enter the thicket, if I may, and compound the problem. A family of 3 or a family of 5 is the applicant for an apartment and gets the benefits of being a family of 3 or 5. 2 leases later, it is a family of 1. Now what? Now that's the housing authority's problem. Let's see where you get out of it.
So that family of 5 with the rent is calculated based on the number of people in the household. So that family of 5 rent is not the same rent for a unit as a family of 1. So that family of 1 now has to be able to pay the rent for the family of 5. So I mean, unlike NYCHA, where the rents are very low, and somebody may be able to carry that large unit, the way the rents are set in HPD programs are based on household size. So there's a household factor, and the rent is not the same if you're a family of 5 as if you're a family of 1. That's a lot of rent to cover.
The bottom line is, if you start out at 5, you stay as 5 for the rent purpose, whether you are 5 or you are not.
No, no.
Yes.
Yeah.
That's what she just said.
I thought she said
No.
they recalculated by the family size to a family of 1. You may have been a family of 5, but you're now a family of 1.
Not unless you don't meet it, right? So.
No, so you come in and you sign the lease as a family of 5, you're income qualified and the rent is set as that. And so they're not recalculating your family size every time they give you a lease. So if all these people leave, your rent is registered with rent stabilization and it's not changing except to increase according to RGB. So that's a family of 1 who's paying a lot more rent than they did when they were a family of 5.
Sorry, I missed that part. Thank you.
No, that's okay.
All right, any other questions? Yes.
Yes, I guess just to piggyback off of that question, if somebody wanted to go from that 3-bedroom to a 1-bedroom because their circumstances changed, do they have to start over? Do they lose their, what's the process for that person?
So Ted, do you want to take this one or you want me to take it?
Well, they would be filling a vacancy, and vacancies have to be filled according to the original breakdown. So if somebody, they would then be looking for a 1-bedroom that has to be filled by somebody who income qualifies for that 1-bedroom.
And.
So in other words, there are some buildings where the agency has allowed people to right size, right? Apartments on a list. Since local law, what is the local law that created Housing Connect? I've forgotten which one, but basically units have to be re-rented through the lottery per that local law. And so when a unit becomes vacant, it has to go through Housing Connect. There are instances, and I've seen some agreements where, especially in housing that was produced prior to Housing Connect, where developers have been able to have wait lists where tenants who are already in residence and want to right size can have priority to move either to bigger apartments or smaller apartments. I think it's local law 67 that created Housing Connect and now requires all units to be marketed for Housing Connect.
All right, any other questions from the board members? Any questions from those who are on the Zoom? I see no hands. I thank you very much. I'm going to, with Farah, notify the Riverdale Press that as soon as this is up on the screen, on the website, for them to look at it and start drafting their apology for inflammatory reports that were inaccurate and inflammatory.
I ask one little question, Marty, I think it was you who mentioned there was an issue about two houses that were reluctant to sell, but
That's not this area.
That's not this
That's
one.
not it. That's over
Van
at Center.
Cortlandt Village.
That's it.
Oh, I'm sorry, okay, excuse me.
Anything else on this subject? Thank you very much.
Thank
I
you.
apologize for
Thank you.
taking your time,
Thank you.
but I wanted the record cleared up.
Thank you.
Thank you for the
We
Have a great night.
everybody else.
Thank you so much.
Okay, now, Marty, give me a minute, if, ladies and gentlemen, to deal with the issue. Over the course of the past few years, we have seen a steady hostility, if you will, on the part of city planning towards SNAD, trying to end it, and trying it again in connection with City of Yesterday. That hostility has not diminished one iota in my view. And indeed, what it has done is it has taken the Department of Buildings, which was an entity that was in favor of enforcing the law, to now being the Department of Buildings that got itself cleaned a few years back. And should get re-cleaned pronto. What do we do about it? It comes up in the context of the problem that Marty raised, which is a developer who just doesn't give a damn. He's gonna do whatever he wants to do, what he thinks is right. It's my property, I have rights as an owner, I'm gonna do what I'm gonna do. That's an interesting view. It prevails outside the boundaries of the city of New York, and the domain of the king. But it is not necessarily the appropriate one. So here is what I propose to do and draft and present at the next meeting. I'm going to ask for an amendment of the city charter and the like. And by statute, I will talk to our city council people on it, to provide that where a city agency declines to actively enforce a law or regulation such as SNAD, and where the community board and responsible community organizations within that area want it enforced, they can make an application to the Supreme Court in that county for an injunction, either in the nature of mandatory, forcing the city agency to comply, or failing which empowering the granting of relief that the court is going to enforce it. In other words, if the agency ain't gonna do it, the communities will have the power to do it through the intercession of the court. I'd like to get your impressions of that kind of an approach, because it makes no sense having laws on the book that people think are protecting them, only to find out they're not being, deliberately not being enforced by government. Laura,
The cost of this, litigation, how is that,
would you
assumed?
provide that the cost of litigation shall be borne by the government in the event it doesn't prevail? In other words, if the agency does not prevail and the private interveners do prevail and get relief, the court can award them a reasonable attorney's fee. Not unusual.
And if they don't prevail,
Then
they're just
they're-
out,
yeah.
they're out of,
Right,
Well-
that's a deterrence to slap suits.
mm-hmm.
Yes.
Chuck, I guess one question would be, who determines and how is it determined that the agency has failed to
The
fulfill its
court,
obligation?
you gotta make it show.
Okay. So you have to come in with your evidence and
Yeah.
so on?
Yeah.
Okay.
And by the way, I have no problem in this case.
Well, no,
I
I mean,
couldn't lose this case and I have lost.
we've had instances where people have photographs and video and so on,
Exactly.
and there were no consequences, yes.
But
Mhm.
now you're talking about the department that I know a little bit about. They periodically go into that kind of a slump. And they periodically have a few people get the benefit of public assistance in a penal institution when they get caught. Yes, Laura.
At what point, do you get buy-in from the groups that would be bringing this? Or or are community boards
That is a
bringing
issue.
it? I'm
That's-
just wondering who has standing.
That's an issue that we need to all think about.
Okay,
I thought about it originally as the community board because it is the statutory and legislative history intended representative of the community. On the other hand, the point was validly made, there are organizations like the Broadway Alliance, with which you are passingly familiar, that does a great deal of work. And maybe they ought to qualify. And maybe the answer is the court shall have the right to grant them status to also be an applicant. Well,
Chuck, the obvious community counterparts are the ones that are, well, in the case of, Riverdale Nature Preservancy, it's specifically there to protect the
Yeah.
SNAD regulations
Yeah.
in the area west of the
Yeah.
highway. In the case of FPOA, they have other responsibilities, but they're also,
right,
empowered to, try to protect the SNAD regulations and field staff.
courts deal with this regularly in a different context, called whether or not to grant amicus standing,
Mhm,
friend of the court standing.
mhm.
And sometimes that has real teeth in it.
Mhm. But what I'm thinking of specifically is if we're talking about the community board taking action, I think in all those instances, we need to have, certainly communication and agreement with the relevant
Absolutely.
nonprofits. Yeah,
In any event, I will prepare a memo for the next land use meeting and a draft resolution for you all to look at and think about so that we can move this forward. I will talk to the Dinowitzes and I will talk to the other council members that act with us and the people from Staten Island who I have been in touch with, and Queens, which is confronting a similar problem. That is I think, a more moderate approach than just defunding city planning, which I would also favor.
Thank you, Chuck.
What about the ombudsman idea? All right, the next item on the agenda, if there's no more on these two, is
You have to approve.
Marty, let's go back to you. Now what do you want to do? You want to still dissolve the committee?
you're muted, Marty.
muted. Hold on, let me ask him. You're muted.
Marty,
Okay. Come on.
Now,
The members of my subcommittee are present, and I will be in contact with them. I will tell you up front that this was not my idea. And
know.
so I will ask them whether or not the proceedings this evening have swayed them one way or another. And I will get back to you offline of what that decision is.
So that takes us to the application of 5294 Sycamore Avenue, a SNAD non-ULURP application. There, an authorization is sought pursuant to ZA 105-432 to facilitate a vertical expansion to existing 2,877 square foot single-story home. The expansion is of 694 square feet to add additional space for bedrooms, being sought by a private applicant, Jonathan Martin, at 5294 Sycamore in Riverdale. I believe Mr. Field Excellent, am I correct?
So, good evening, everyone. John Field here, Building Studio Architects. I'm here with Yale and Jonathan, my clients, the homeowners, and I'll present this as efficiently as possible. I appreciate that Camilla's also here from City Planning. And if I can share screen, I can jump right into this.
Great, let me do that. Okay.
So on my screen, this is the first page of our city planning application. This shows our parcel at the corner of 245th Street and Sycamore Avenue. It is in the Riverdale Historic District, so this is also a landmarks project. I'm going to introduce it briefly here on city planning's terms, and then we'll switch to what it looks like under landmarks. The existing house is here at the back corner of a very large lot. It's accessed by driveway up from 245th Street. This is a long driveway. We have an existing brick garage here at the back corner of the lot. This is where we are doing our vertical expansion. The expansion is to provide additional living space, bedrooms upstairs for Yale and Jonathan's children. The downstairs is going to become a living room. This is a city planning action because the site is beautiful, steeply sloped, treed, and we are building to minimize impact on that. And it is in the setbacks, which are allowed to be modified under the zoning resolution. We will also be planting 6 trees here in the front of the yard. If I now switch to the landmarks presentation. Oops. Bear with me. This is the house viewed from their terrace, sits high above Sycamore Avenue. Let me just note in the back corner here, you can see a piece of the garage. This is where our addition will be. The site again is at the north end of the Riverdale Historic District. Outlining where our addition will be. I'm going to go through these quickly because with landmarks, we have a lot of views. There is limited visibility up the driveway of the house, which had a previous enlargement about 20 years ago. This piece in the front, it's a sunroom, breakfast room, and entrance was added. The garage is here uphill. This is from within the driveway. And this is where we will be building an addition. This documents the former addition that I just showed.
Have you been in touch with the Riverdale Historic District?
Absolutely. We've been working with landmarks on this for quite some time. You'll see the result of that in a moment.
How about the owners of property in that area?
We have notified almost every house within the Riverdale Historic District and within 400 feet of the site. The Martins have spoken to their no responses. The Martins have spoken to their direct neighbors, know them well, And they're in favor of them remaining to be homeowners in the district and do this addition.
Chuck, I have one important clarification, if I may. Is it the case that this house is situated at Sycamore and West 245th, as the map says, or is it West 254th Street? Yeah.
It is 250, it is 254th.
Yes, that's what I thought. All right, the first page says 245th, it's a typo.
That's good. I have a typo. Thank you for clarifying. We'll go through and correct that.
Now you're my neighbors.
That's right. That's right.
So that's okay too.
I mean,
But let's not, we don't want to confuse everybody. This plate is here to offer a comparison of floor area in the district and the scale of the houses and the lots. Even with our addition, we have at the much smaller houses in the historic district.
you did not notify me.
Yeah, it's okay, it's okay.
Why is it, I was not notified?
Of the addition behind
Well,
main
of the
house.
applicant. I was obviously notified as the board. I was not notified
As an-
as an owner. That's why I asked you the question.
Understood. We did send notifications. I know the board was notified. We sent notifications to everybody within 400 feet of this.
But not everybody within the historic district.
Almost everybody within the historic district. And if you're beyond that radius, I apologize.
It raises a question in my mind as to whether or not tonight is the appropriate time to do this until you notify everybody.
The requirement is for 400 feet within the district.
I understand what you're required to do. I also understand what people who are thoughtful do.
I'll tell you, Mr. Field, almost every page says 245th Street, correct? Almost every page, and it quite boldly.
So the argument would be that you've not accurately informed the board.
May I continue?
Sure, but just
Okay.
think about the following question. Don't you think you ought to come back next month after having notified the rest of the people involved?
I think that notification has been duly given. And if I can continue the presentation, we can look at what this is and the board can make a recommendation.
Can I ask a question on this plate?
You may.
To the left of the former garage, now addition, there's a gate. What is that gate
This
open
is,
to?
this gate opens to a house that sits on the hill. Mr. Martin's neighbors, you can see it here where the cursor is. In the back corner, Mr. Martin owns the driveway. This house has an easement across the driveway. That remains unchanged.
And to the left of the gate, is there a driveway there?
When you go through the gate, there's a garage. There's
No, when
like
I go up to before the gate,
No,
and I'm gonna go left right before the gate.
nothing.
Nothing, okay.
This is another piece of property. So our addition here is of brick. The shutters, the window fenestration, the detailing is taken from the design of the original home. There are other houses in the district that have had additions, especially above garages. This is uphill from us. In Fieldston, which Landmarks also looks at, since Riverdale's a small district, they have approved similar treatments recently. And on the ground floor, we are on grade here. This is the former garage turned into a living room. And on the second floor, we're adding 3 bedrooms and 2 bathrooms. These are not large bedrooms by any stretch, they're petite. But they will provide adequate space for his growing family. We have elevations. Materials in keeping with the existing home. Slate roof. We'll get a new slate roof on the addition. And that's the Landmarks proposal. If I switch back to natural area,
Do you
I
know,
will-
can you tell me how your client would be prejudiced if this were adjourned to the April meeting and you were asked to submit a corrected set of application plans, correctly identifying it as 254, not 245?
we have been working on this both with Landmarks and city planning now for years. And city
What's a
planning,
month?
what's
that
years? 3 years. This project
What's a
has.
month in that context?
Well, the month in that context, city planning has cleared this through their calendar and is in their final review process. That will remain unchanged. We would like to keep this moving forward with Landmarks at the same time. And so Landmarks and city planning require a hearing together. We've been waiting a long time for this hearing because of the city planning process. Now that we have that, we can continue forward with the Landmarks process.
Wouldn't that presuppose an accurate application rather than one that is deceptive?
I think there's no deception here in this application. There is
I will
clearly a
tell you this,
typo.
sir.
I do not disagree. But
I will tell you this, sir. I did not until about 15 minutes ago realize it was I'm a neighbor. And I am directly affected. Do you think there are people at city planning who don't actually live right there, who might actually believe it's at 245th Street?
Which is a mile away.
There is no Sycamore in 246.
This is not,
No, you're right.
This is not your client's fault. It is whoever drew this.
it is, I'm not saying it's not my fault. 100% my typo. 100%. No disagreement. And if we messed that up, we own it. But it's not material to the presentation. Your agenda clearly has 5294 Sycamore Avenue as an address, and we have a correct block and lot. It's been properly noticed, and this is a valid application. A typo in the plan is something that will be corrected in the city planning final process, I can be sure.
I would repeat, until 15 minutes ago, I did not realize I was looking at something that is not a mile away, but is right down the block.
I don't know how to explain that.
If I had not
The-
been
the-
hospitalized between the last meeting and this, I would have visited the site and would have known it.
The
Which is
cover
what I-
sheet is the Landmarks presentation, which is actually the front part of the package that everybody received, is perfectly clear.
I'm looking at the first page of this, it says 245th Street.
You're looking at the back half of the presentation that was the city planning application. And all I can do for that is apologize.
Also, the zoning application and our agenda today refers to this project as an addition to a single-story house. But it's clearly 3 stories.
That one, I don't know where the language for this comes from. I don't know how your agenda gets typed up.
The zoning application portal too, that's saving that text.
Does
That's
this
your
come
project.
direct, does this come directly? I don't know that. Does this come directly from city planning? And this is an error in entry from the city planning side and we'll have to correct it with them. I don't know such things. Camilla, maybe you can speak to that?
Yeah, good night, everyone. Can everyone hear me okay?
Yes.
Hi, good evening again. Very sorry about the errors in our website. Unfortunately, the lead planner or the project manager for this particular application could not attend. But I'll be sure to let him know that there were some errors in the transmitter letter that was sent to the board. And in the zoning application portal, there is a mistake that it says that indeed it's a single story house, but that's not true. I think in terms of John's application right now, like John said, this could be very quickly corrected. Of course, I will not tell the board how to deliver, how to decide on the project, but we will make the correction on the zoning application portal, and we'll probably ask for another revision post filing or post referral, so that all the documents are clearly labeled. Like you guys have pointed out, there is the error of the address. But in my humble opinion, I think if you like to move forward, I think the documents, aside from that small mistake, are correct. But again, we will be making the appropriate changes in our in the zoning application portal. Again, very sorry about this.
I don't know why city planning needs to be sorry. It's the applicant. And I would not charge this to city planning at all.
Just a comment, I mean, this error occurs 9 times in 12 pages. And frankly, 1 month would not materially affect your ability to do the work in good weather and enclose the space this year in a good working season of, good weather to enable the project to move forward. And the concern that Chuck raised about other neighbors, I mean, what has been a policy of this community board to make sure that everyone relevant is informed and that there's no reservation. I don't imagine, frankly, that there will be major reservations to this, so I don't see the reservation to taking the month and making sure that all the Ts are crossed and all the Is are dotted.
And with all due respect, we will take the month. We will see that the Is are crossed and the Ts are dotted. And we will re-notify the 400-foot radius required by statute and continue forward.
Let me be quite clear, from a purely.
Mr. Chair,
Who's that?
Marty?
Yes.
And the owners have their hands raised too.
I'm just a little bit concerned with the question of notification of neighbors. As I look at the diagrams presented, the impact on at least one neighbor is major. And I'm sure the other neighbors surrounding have concerns, maybe zero concern or major concerns. But I would like to know that in writing, each of those neighbors, having been contacted, have put into writing that they have no difficulties or do have difficulties, and we're voting on the full package, so we know exactly what we're voting on.
Here, let me give you my own comment to it. I personally think that this is not a bad application. I really do. But I do think it is wrong that we have it in the context of 2 major errors, one more serious than the other, namely something that was a mechanical error that should not have occurred, and careful work would have prevented it. The other is the description of the size of the house. I'm therefore going to move to lay this over to the April meeting. Who else is?
The owners.
Oh, absolutely, folks.
Good evening, everybody. Thank you for your time and your patience. My name is Yael. This is my husband, John.
Hi, everybody.
Thank you for reviewing this application. As Mr. Field mentioned, we are many years into this process. Thankfully, our kids are growing very quickly. To the question of timeframe of this project, many of our kids are away for the summer, so ideally, we would like to get a bulk of the work done when our kids are out of the home, which is why I think a month delay would impact us more than you might think otherwise. That is in terms of the impact of a delay. On the subject of notifications, I apologize that you weren't notified. You might have seen me smiling when I heard you discuss this because I got around 6 text messages from friends of ours in the neighborhood with pictures of Mr. Fields' letter saying, very exciting for you. We're very excited about this. The response has been extremely generous in the neighborhood. As to the specific question about the neighbors with whom we share a driveway, we are very close with them. They just came over about 2-3 weeks ago for at least an hour and a half, and we shared the plans with them. They are extremely gracious, and since there is a burden on them with closing a shared driveway for the duration of the project, we made sure to keep them in the loop from the beginning, and they are more than happy to speak or share offline on our behalf. If possible, I would like to ask this committee to reconsider the delay of the month. I understand there was a typo in the application. Mr. Murdler, you're invited to walk over here tomorrow morning for coffee and I will walk you around myself. But with respect, I would ask you to please reconsider our delay.
Ma'am, this has 2 failings that trouble me greatly. They are, one, that we have insisted on notification of people. I have no doubt at all that what you say is 100% accurate. But there have been times that we have had in this board not a strong statement as you have just made about what people have done and different excuses for failure to notify. You have one exception and you're down a slippery slope. That would not be enough to deter me. But the fact that you have replete with this application, something that must have struck you when you read it, the first part, West 245th Street is right at the top of the plans. That must have struck you. You're obviously exceptionally intelligent people. My point is, if anybody else looked at it, it wasn't just me. I'm going to continue that motion. And I will tell you, by the way, unless I hear something to the contrary, I will vote for this application when it comes up, because I don't see any problems with it, other than a procedural problem that really taints it. It wasn't your fault.
This is not about placing blame. This is about coming together to find solutions forward and to try, we're very good members of this community. We absolutely love Riverdale. But if you have a family that says timing is actually an issue here, and we have been trying to get this through for years, and there's a typo problem, please understand my frustration.
I do. And let me tell you what we did at this board, and we've done, we put your thing right on the calendar the moment it came in to try and move it forward. That's not what we regularly do. You got on 1, 2, 3 because you merited it. But here you have a problem. You can't hide from that problem. It's right on the face of the application.
So nobody is hiding from any problems. I'm beholden to your decision this evening. I just wanted to voice my opinion. Thank you for your time.
I thank you. I understand your view. I really honestly do. And I tell you again, if this comes out next month, and please, I have one more request to make. If this comes up next month in the same posture, I intend to vote for it. I intend to move the resolution. Because I think it's worthwhile. People are entitled to do with their property good and proper things, and there's nothing more proper than what you propose here. But it's defective right on the face of it. So that is my recommendation to the committee. I will make one more request of you if it does go over. Would you try and get something in writing from those immediate neighbors, please, saying they're on board? Because in the normal course.
Sure, I
of
think,
events-
I apologize for interrupting you. The burden on us as a family with 5 children sharing one bathroom to get this project going is crossing a line into untenable. You're welcome to reach out to my neighbors again if you'd like. I've reached out to my neighbors enough. I feel like you are making it difficult for families to create spaces in Riverdale. We've gotten to a point where I understand that there's a typo. If you want to push this off for a month, that's okay. I don't want any more homework on this project that's been going on for years.
Not here. Not
Perhaps,
with
but
us.
please consider it from my perspective.
You applied to this board, it put you on the calendar immediately.
Yeah, I agree, but this board understands the journey that we have been through. So I understand, you're getting us at the end of a long journey. We are fatigued. With respect, I'm sure Mr. Field will help problem solve and will find whatever solutions for next month's meeting.
We'll be working with city planning. We will correct the drawings. We will correct the addresses, and we will do what we can to see you again next month. That's what we can do. I hear what you're asking for neighbor. I heard what you're asking for neighbor letters. We will do our best to achieve something. Neighbors don't always like to speak up publicly. They don't come to these
That's what I'm
hearings
saying.
either.
If you have a problem, in terms of embarrassment or actual problem of getting your next door neighbor to send a letter, let me make this alternative suggestion to you. You would write to them with a copy to the board saying, I want to thank you very much for your support of our application or non-objection, and thank you for it. Copy us. If there's no response from them, I can take that as an acquiescence. All right?
We
On the
will endeavor.
motion- On the motion, is there a second?
Second,
Any discussion?
well, the motion is to postpone discussion for 1 month.
For
until
1
the next meeting. Yes.
All those in favor? Unanimous. Thank you very much.
Thank you, Chairman. Thank you, committee members.
Very well. Is there any other business to come before the board?
Yes.
The minutes?
We have to
Ah.
approve the minutes.
I always forget that. Damn it, I'm sorry. You have the minutes. Are there any comments or corrections? May I have a motion?
Motion to approve.
Second. All those in favor? Contrary minded? Done. Any other business? Oh, yes. One other question that my friend Mr. Gelman reminds me of, because he mentioned it to me earlier, and I had forgotten it. One of the thoughts of dealing with this failure of several let me take you back. I was there with Fritz Schwartz, who was then the corporation counsel, and who I had worked with together at Quebec, and who was an exceptionally able and wonderful gentleman. When the community board concept was really strengthened by him. And one of his ideas was, and you will see it in the historical references, was that community boards were supposed to be a reflection of the community and designed to try and create something of a balance between centralized government and decentralized popular government. And the boards had their purpose in trying to be a funnel of information. They were not given the power to veto governmental action, but they were given the power to speak up and state their views, and the city was required to be in a position to listen. It was for that reason that the original draft of the boundaries were tailored to being equivalent to the police districts, the sanitation districts. There was parallelism so that each community board would have approximately the same boundaries as the 5-0 precinct would have to us. And that was this concept. Indeed, in the original, it was contemplated that many of the actions of city planning were to be coordinated with the community boards. And they were not called community boards, they were called community planning boards. That was the original title. As often happens in this kind of a contest, there's a constant tension between centralized government and decentralized government. We are now on the centralized government kick, with the king at the helm of it, I suspect. But
This was the argument between Alexander Hamilton and Thomas Jefferson, writing the Constitution, how centralized and how decentralized.
Exactly.
So it's almost 250 years that we've been conducting this argument.
Goes to show you how old I am. The point I'm trying to make here is very simple. David had the thought that maybe one of the ways that we can bridge constant, and it has been constant difference and tension between CPC, or really Department of City Planning, and this community board and others, and we're not alone by any stretch of the imagination, nor are we at the forefront of the movement of trying to do something. His idea was, why not have a community ombudsman within the Department of City Planning? And so that there would be somebody in city planning who would be there to say, hey, listen, where's the community board in this? Where's the community? Forget the community board. The Broadway Alliance wants this, or Fieldston wants this. People like that. And that's a good idea. I'm gonna throw that into the package. You folks will think about it now, okay? Any thoughts?
I just want to add two comments. One, the genesis of this was Chuck's frustration and the lack of responsiveness from city planning. His idea was originally that as a budget item that we try to take on the idea of recommending reducing budgets of agencies that don't cooperate with us. And to be fair, this idea, this brilliance wasn't mine. It really came from Rosemary Genty, who is well versed in the operations of the city of New York, and her idea was to place an ombudsman, at least at city planning, but maybe other agencies. That's for later discussion, but I think there's a lot of validity to that, and that we could, we could do that. And part of this comes from, for example, City of Yes was approved by the majority of the borough presidents, but was turned down by the vast majority of the community boards, and it went through anyhow. And so,
Although I suspect the newly announced candidate will soon announce his views on the city.
I know. So,
And that's a little more than a guess. In any event, think about that. I've put it in as a rider to the concept I talked about earlier. And think about it, so we do it not on the spur of the moment, either which way. Is there anything else to come before the committee?
Well, I have one comment, but are we still recording?
We are. Do you
Okay,
wanna
I
wait?
have no comment at the moment.
Is this new business?
Yeah.
Because I'd like to talk about the charter revision that's taking place in the Bronx tomorrow night. And it already took place, I think, in Queens and Brooklyn. Staten Island will be April and also Manhattan. We don't know what is in front of them, to my knowledge. I believe I had read something about changes to ULURP and all changes, but from what I understand, there will be a panel discussing I don't know where the panel comes from, what ideas. It's going to be, the topic is land use and housing. That is the topic of the charter revision.
And you got the email I sent everyone today.
Yeah, today, yeah.
right. And where is it? I didn't open the email yet. Where's the meeting
Well, I
tomorrow?
know it's on Zoom, but it's also at
It's
Fordham.
Fordham area.
I
you.
think that we should discuss this next month. Hopefully, we'll be able to see what,
Darren, make sure
what's-
it's on the agenda. And would you resend the email, please?
Is this the
telling
one
us
with the
the times
legislative
of the
update?
debate.
For the
No,
meeting?
I
saw that one, that was
No, no, no.
This is,
No,
this
just
is
came
charter.
today.
It just came
revision.
I'll print it for you.
Yeah, and they, and you know,
It's in your inbox today.
if you go to the website, they are taking comments. But of course, we don't know what to comment right now because we really haven't heard what's on the table.
I don't even know who the members are.
It's on their website.
Eduardo's one.
Who?
Eduardo.
Oh,
I didn't. There was one or two names that I knew. The former city planning chair, is a member of the charter commission. You might know the names. I don't have it in front of me, but I was reading about it today. And, I think that we need to follow this.
Oh, yes. Any other business? Do I have a second to my motion to adjourn?
Second.
Done? All those in favor, contrary minded, done. Thank you very much.
Thank you, everyone.
It's the opportunity for a community to testify, so it's actually